Welcome to the Legal View with Farah Farah. I'm Chuck Farah, and with me today is my partner, Eddie Farah. Eddie, what's on your mind today?
Well, Chuck, I want to talk about slip and fall accidents and what to do if you've been involved in a slip and fall accident. Under Florida law, whoever controls or owns the property has a duty to maintain the premises in a reasonably safe condition. Now, just because you go into someone's house or you go into a big box store and slip and fall in some water doesn't mean that they're automatically responsible for your injuries. You have to prove that the owner knew or should have known of that dangerous condition. Let me give you an example. Let's say you're at the neighborhood grocery store and you're in the produce department and you slip and fall on a banana. And that banana looks like it had been spread around the floor and that it had been trampled through numerous times. That's evidence that the owner knew about that dangerous condition. At the same time, if you look like you were the first one to step on that banana, it may be difficult for you to prove that the owner knew about that dangerous condition. There are other ways you can prove this by circumstantial evidence. For instance, maybe there was someone in the store shopping that you know that was there for an hour before you were and remember seeing that banana on the floor. That would show that the owner knew about it and should have done something to clean it up. So circumstantial evidence is another way to prove your case.
Yeah, I mean, if you're a victim of a slip and fall accident, there are a list of things you should do to preserve your claim. The first would be to report the accident immediately to management or the property owner. The second would be to get the names, addresses, and phone numbers of all witnesses that saw you fall. The third thing would be to take photographs of the area if you have that capability. The fourth would be to preserve any physical evidence that you have, for instance, clothing that may have been wet from the fall. We're able to test to find out what kind of substance you may have fallen on. And the last thing would be to call an attorney immediately, because an attorney is able to preserve the evidence and send out a preservation of evidence letter, which will preserve any video that may have recorded the fall.
Yeah. I'll tell you one other thing, a lot of times people don't realize is that whatever the employees say are admissible against the employer. So if an employee runs up to you after you fall and says, "Oh, the manager told me to clean that up, I didn't get a chance," that is an admission that can be used against the employer to prove that he knew about that condition and should have cleaned it up.
You're right. I mean, a lot of people after a fall, they're embarrassed and they really don't think about how to protect themselves. And you have to get over that embarrassment and really think about, what do I need to do now in order to preserve my claim and to make sure I'm protected.